fraud is inarbitrable, and therefore the learned arbitral tribunal does not have jurisdiction. The learned arbitral tribunal's finding is there that fraud was contended in a criminal complaint. It is not contended in these civil proceedings before the learned arbitrator. While filing the criminal contempt, I said you have committed fraud in diverting the funds from that escrow account. That is the element of fraud. The learned arbitrator has given a finding that that is not something that vitiates the entire transaction, and it is not one that requires complicated evidence. And therefore, Ayaswamy, the Supreme Court judgment, will not come to the rescue. It may not be applicable in the facts of this case, and says that no, there is no fraud here. Criminal complaint, if there is any fraud or anything, the criminal trial can go on separately. These were the grounds urged then. These were the grounds reiterated before the learned district court under section 34. Here, my lord, now argument is being sought to be raised that penalty was not ignored. The obligation to pay 23 crores is conditional. No, these were not even pleas. And anyway, I have an answer to that also. The other argument raised for the first time now before this honorable court is that the settlement agreement has been given the go-by because my cumulative relief that I sought before the arbitral tribunal amounted to 37 crores, which is 23 crores plus the 14 crores damages that I see. Therefore, having claimed the amount that was otherwise due to me, I am deemed to have given up the settlement agreement. These are the arguments raised now. The records will show these are not the pleas. These are not the arguments. And is it in arbitration jurisprudence permissible for a party to come and raise such arguments now? The answer is a straightforward no.
What argument?
The arguments that were not raised before the tribunal. Pleas that were not urged before the tribunal. In the pleadings, in the statement of objections, my lord, drafting, everything is mentioned, all and sundry.
Is that argument not urged before tribunal?
Twofold. One, penalty being a part of the contract. The
What penalty?
Penalty. Sharing of penalty being part of the contract. The obligation to pay was conditional upon such sharing of penalty. That it was a conditional obligation. This is one proposition. Of course, well, yeah, appellants may clarify, but this is what I have understood as being their proposition. And the second argument, which I submit was not raised before the learned arbitrator, is that the claimant is deemed to have given up the settlement agreement.
That was not urged.
That was not urged. No, the reading of the arbitral award will show that. He is deemed to have given up the settlement agreement because the cumulative amount of claim sought by the claimant is 37 crores, which was a subject matter of the settlement prior to the arrival of the settlement, prior to the execution of the settlement agreement. Subject to correction, my lord, plain reading of the records will show. In their I will reiterate this. In their statement of objection, somewhere here and there, words will be found, sentences will be found on these points. Was an issue framed by on this issue on these two pleas? The answer is no. No issues were framed, and nothing prevented the respondent, then the appellant herein, to request the arbitral tribunal to recast the issues. If they were so vehement and so insistent on that these pleas also ought to have been considered and that the learned arbitrator has ignored these pleas, then nothing prevented them from requesting the learned arbitrator to recast these issues.
According to you, this settlement agreement remained
Unchallenged.
and source of undisputed obligations between the parties before the arbitration.
That is the finding of the learned arbitrator.
Source of undisputed obligation.
That is right.
That is also very specifically I am using.
That is right. That has been my specific plea, and that is a specific finding of the learned arbitrator, that you have not challenged or questioned the settlement agreement in any manner. You may dispute the obligation thereunder, but the execution of the agreement, the entering into the agreement is not questioned by them. No declaration is sought, no counterclaim is filed. The learned arbitrator says, I am a creature of the contract. This is the contract. You are not questioning the contract. What do? I will allow the claims under the contract. I contended that.
It was your invocation of the agreement.
That's right. I invoked.
And you gave up that part. You really resiled from in a way.
Which is what I'm submitting. I did not. It is their contention to pursue at this honorable court that I did. I did not. I have not resigned. I have not given up. In fact, my lord, to answer that there is a very straightforward answer to this proposition.
If you resile from, if they are right, then they are also entitled to back out.
Correct. Absolutely. Absolutely. If I have result, then they are also entitled to resell. Absolutely right. That is what they are seeking to urge now for the first time before this honorable court. Firstly, whether such a plea can be even heard. That is the first hurdle that the appellant needs to cross. Whether such a plea never raised before the learned arbitrator, never raised before the Section 34 court, that too in an arbitration jurisdiction, can it be urged for the first time before a Section 37 court? That is the first hurdle. Second, assuming that the argument can be heard, is there any merit in that argument? The answer to that is Section 21 of the Specific Relief Act. If, my lord, the Specific Relief Act can be seen, what did I seek before the learned arbitrator? In volume 1, my statement of claim, the reliefs that I seek, my lord, are set out. Volume 1, my statement of claim. At page 320 in the paper book. My lord has it. Prayer A, directing the respondent to pay the claimant a sum of rupees 4 crores with interest thereon at the rate of 18% is specific performance of their obligation, clause 7 of the settlement agreement. Prayer B, directing the respondent to pay the claimant a sum of rupees 23 crores together with interest thereon at the rate of so and so is specific performance of their obligation under clause 1. So prayer A and B are specific performance prayers seeking specific performance of this settlement agreement. Now prayer C, directing the respondent to pay the claimant a sum of rupees 14 crores by way of damages, not due under the invoices prior to the settlement agreement. If, my lord, my prayer A was simple, direct the respondent to pay 37 crores. They have committed fraud. They have diverted the amount from the escrow account. Therefore, the settlement is gone. Now you ask them to pay me 37 crores. That would be a clear case where I have given up on the settlement agreement and I'm making a claim now on the original invoices. I have provided services. I have raised invoices. They were supposed to pay me 37 crores. There were disputes and differences between us. Therefore, we arrived at a settlement agreement where they persuaded me saying, agree to 23, I'll pay you 23. 23 has not been distributed, 17 has been distributed. Therefore, settlement agreement has been given the go by. The learned arbitrator gives an explanation for that also. He says 23 is what you expected. 23 has not come because what the clause 3 says, clause 2, clause 1 says specifically, they agree to pay me 23, subject to whatever comes from the government department. So the learned arbitrators, and I go to the arbitrator and say, see, they promised to pay me 23, ask them to pay me 23. The learned arbitrator says, subject to what comes from the government department. No. What has come from the government department? 1753. So I will distribute 1753 according to 60/40. That is the interpretation given by the learned arbitrator. Tomorrow, my lord, only the award and section 34 and I'll close.
Any matter, 230 matters,
Two-
any other matter.